First case to come before us is State versus Simon, and these are Medina cases today, and I don't want to speak for the other judges, but for me, I just show up where people tell me to show up, so I appreciate, for whatever reason we're holding you here today, so I appreciate your accommodating the court. All right, you each will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. And I will keep the clock for you. Just tell me how much you want.
Thank you, Your Honor. May it please the court. Attorney Wesley Buchanan, I represent Trebor Simon, and I'd like to reserve 5 minutes for rebuttal.
That's fine, thank you.
The purposes of felony sentencing in this district have been laid down almost ad nauseum with State v. Kalish and the two-pronged test. Trebor's argument is that his sentence was contrary to law because of the factors that were not considered at his sentencing and during the hearing. The trial court specifically did not take into one of the factors into account by indicating that it was not the court's problem at the sentencing. So it was an explicit vocal indication that that factor had not been considered. And the governance of the Kalish test has been overruled by 295308 subsection G, where it actually specifically delineates what the appellate review standard is, and it is on the appellant to show by clear and convincing evidence that the sentence imposed was not supported by anything in the record. In this case, there was a PSI which has been submitted to this court, and the PSI is replete with the facts and circumstances that occurred. And trial counsel did indicate and point out the various different factors to be considered at the sentencing hearing.
Interrupt for just a moment. The statement that was made by the trial court, I think it's not my problem.
Correct.
I'm wondering if there are other ways to consider that or to construe that other than that the court dismissed it. For example, could the trial court have been saying, okay, I understand, I take that into consideration, but ultimately he bears the responsibility for it. Do you understand what I'm saying?
I do, and I believe that there could be multiple interpretations of, no, not my problem. The transcript does have that a couple of different times. So the implication, if you will, and the connotation implied by the record is, no, not my problem. No, not my problem. Implies that it was no consideration may have been taken into account by the trial court. Could the trial court have meant something else? I'm sure the trial court could have, and I would be speculating at this point to determine what the trial court would have been thinking exactly. But yes, there could be a different reason for what the trial court indicated.
Sure.
And I would indicate, at least for purposes of today's, why we're here, the sentencing factors taken into account in the PSI had a checklist that go over the statutory factors. And some of those statutory factors were not checked or left blank or something else like that. So we can infer that maybe they were considered, or it was a null, meaning that it didn't weigh one way or the other, or we can infer that maybe they did not take that into consideration. So I mean, there are two different ways that could be considered. Given the extensive fact pattern given with the PSI, I mean, you have a situation where Trebor completed the 10th grade, a young woman runs away from home at 4 in the morning, spends half an hour searching Trebor out at his apartment in December in northeastern Ohio, where it's cold. Eventually, through social media, finds Trebor, communicates with Trebor electronically, and then enters his apartment. He was concerned about this being a setup, which was indicated with the facts in the PSI.
Now, let me ask you a question. It seems a little confusing. I know we're not looking at sufficiency here, obviously.
Correct.
But it seems a little confusing to me because there was the allegation that he thought at first she was 19.
Correct.
And then she had posted that she was 15, I believe. And she said, I think I'm 15 because I'm almost 15 or whatever. But if he thought she was 19, then why is he so worried about getting in trouble and so forth? Seems a little inconsistent.
I would agree that there are inconsistencies with the fact pattern. I think his concern was being assaulted. I believe the statements that he made to the police were that he was concerned about being beat up or assaulted.
By the police?
Not by the police, by people that this girl may have known, or family members. So I agree that there are inconsistencies, both that are favorable to Trebor and that are not favorable to Trebor in this regard. And one of the sentencing factors that the court would take into consideration among the other statutory ones would be facilitation by the victim, whether or not the offender was provoked by the victim or anything else like that, whether or not physical harm was occurred here. Everybody agrees in the fact pattern this was a consensual encounter. No rape was alleged.
So much as a 14-year-old really.
Correct. That being said, I mean, the facts...
what you're saying is physical force.
Correct. No physical force was what occurred here, and no threat of physical force was used, and no weapon was used, or any threat of weapon was used in this case. Trebor does have an extensive juvenile record, as was indicated in the pre-sentence investigation. There was a denotation of scheduling issues at the trial court level, whether or not he did violate a capias was issued. Trial counsel did explain that to the court, saying that it was a scheduling error on his part, so Trebor had appeared every time that he had been ordered to do so. So I would indicate that in so much as the factors were considered in the journal entry, because the journal entry of sentencing does denote that the statutory factors were taken into account, the language seems to be more boilerplate than anything. And then the actual sentencing transcripts indicate the arguments had by trial counsel and the sentencing court in regards to the scheduling issue, in regards to the facts that she did seek him out for a half an hour at 4 o'clock in the morning after having been thrown out of her house by her father, who she was supposed to be with at the time, leads to a situation where Trebor acknowledges his culpability through the plea of guilty, and then trial counsel says this is a term where community control sanctions, because it is felony in the 4th degree, community control sanctions would be not seriously demean the situation of the offense, and it would not be a burden on local or state resources, because those are the purposes of the felony sentencing guidelines.
But that doesn't take into consideration all the other photographs.
Correct, and there was only, and indicated in the record, there was, the government did try to indict him, and it was my understanding that he was no bill on other offenses. And it was alluded to through the transcript when the government made comments to, he's got a pattern of conduct, pattern of trying to seek young girls out and everything else like that, but no pattern was established through these offenses.
Well, did he speak to the probation officer for purposes of the PSI and discuss the charges that were being considered against him?
It is my understanding that the statements that he gave for the pre-sentence investigation was that he acknowledged his culpability, but he did not give any other statements. Most of the information from the pre-sentence investigation was taken from police records and the internal databases that the police use, and public police reports, and then their investigative purposes. I think there was a denotation in the PSI that Trebor did acknowledge his culpability, did acknowledge that he was doing something wrong.
With this young woman?
With this instance, but did not acknowledge any other instance or situation.
But there were police reports regarding the other minor that were part of the PSI.
It is my understanding that there were other police reports in regards to his communication, but no charges were brought. So as far as a pattern of activity using is there a different interpretation of this statement? Then yes. I mean, if you want to use the term, was a police report filed to establish a pattern, you could interpret it that way. That's certainly a way to interpret it. But given the situation that we're in right now, there were no other charges filed or other charges brought, and there was a specific instance where the government did try to bring charges. However, the grand jury didn't appeal it. So,
And will that information be in the PSI?
I believe it was. I believe it was in the PSI was one of the situations that occurred, and in this instance, I believe there was only one photograph found, and the police could not find or ascertain the age of any of the other people in the photographs. So while there were other photographs found, the ages of the people in those photographs was not conclusively established. So another thought to consider.
You're just starting your rebuttal time if you wanted to say that.
I will save my rebuttal time. Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, my name is Matthew Kern on behalf of Boone Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. This appeal before the court this morning contains a single assignment of error challenging the sentence imposed. And I think it's important to note, if I can pick up from the end of Mr. Buchanan's argument, that there were 2 counts in this case, and the 2 counts pertain to separate victims. The first count, the felony of 4th degree unlawful sexual conduct with a minor count, pertained to victim A.B. The second count pertained to another photo found on the phone that the grand jury did indict on a felony of the 5th degree, and that for which he did plead guilty and for which he was sentenced. And that was an illegal use of a minor in a nudity-oriented material. So I think Mr. Buchanan may be insinuating that there were several photographs found on Mr. Simon's phone through a search warrant. There were lots of what police suspected to be downloaded pornography, and there were also images that were clearly sent by real people that Mr. Simon knew, either emails or text messages, which contained additional images. Now, those additional images, beyond the picture for which Mr. Simon was indicted on the felony of the 5th degree in count 2, may be the subject of this additional argument this morning. However, I think it does bear support in the record that there were photos for which Mr. Simon was indicted, specifically at least a particular photo exposing a minor's female genitalia.
Was that minor identified?
Yes,
With respect to the second count?
I believe so.
Well, I guess, if not, how would we know that it was a minor?
Indeed, Your Honor.
It was not clear, I would just say to me, from reading the briefs, that these were 2 separate individuals.
Yes, I agree. As a matter of fact, I was just looking through to see that because I'm like, boy, that's something I missed.
Well, I believe the state in its brief did not identify the second minor by initials, and I think that may be part of the confusion. But the transcript, and I believe the transcript and maybe the indictment might be clearer for the court's consideration in the record. These are.
It's on the bottom of page 4. It identified as CD, a 15-year-old female. So it is in the brief. Happens to.
I just point that out for the court's consideration in terms of separate victims establishing a pattern of conduct on Mr. Simon's behalf that the court did consider in imposing a sentence. I think if I could start back from the beginning of the appellant's brief, though, in terms of argumentation purposes. The first argument that the appellant makes is that the court's sentence is not supported by findings. And I think it's important to note that this is not a consecutive sentence case. This is not one where the trial court imposed a 12-month sentence on count 1, a 6-month sentence on count 2, and then ordered the sentences to be served consecutively. The court ordered them to be served concurrently, a 12-month sentence on count 1 and a 6-month sentence on count 2. Both of those are clear within the ranges under 29-29-14, A4 and A5, respectively. The sentence is clearly not contrary to law in that sense. And as for the argument that it's not supported by findings, obviously, as the court is well aware, post-Foster, findings are not required for more than minimum or even maximum sentences. The only time findings are specifically required on the trial court's part is imposing consecutive sentences. That's not the case in this instance.
And I realize we have a case law that says from this court as well as different. We presume that the findings were made. But what about when a court specifically says it's as the argument's made here. It's one thing from a silent record to presume, it's another when somebody may indicate that they're not considering something.
Well, and I disagree with the appellant's characterization there, and I actually made a note that was where I was going
Oh,
next,
sure.
Your Honor.
Go ahead. Well, then, I just did the segue for you.
No, I appreciate that. When the court indicated in response to some of the argumentation at the sentencing hearing that that wasn't his problem, what the court's indicating, at least in my view, obviously that's for the court to decide, but at least in my view, the court's indicating there that I'm considering that, but I'm giving it little or no weight, right? When the court's fashioning a sentence, it has to consider the principles and purposes of sentencing, the risk of recidivism, the seriousness of the offense, and fashion an appropriate sentence under all of the factors that it's supposed to consider. That's black letter law. What the court also has the ability to do, though, is based on all of those factors, use its discretion and determine what sentence it determines is appropriate. And it does that by weighing all of those factors. It doesn't have to say, oh, well, you meet the seriousness and recidivism more likely factor 1, but you have 2 less likely factors, therefore, by law, I have to impose some particular 6-month sentence versus a 10-month sentence versus a 15-month sentence. The trial court has the ability to weigh the seriousness of the offense, all of the additional factors, the risk of recidivism, all of the factors in 29, 29, 11, 12, and 13, and fashion what it determines as an appropriate sentence. In this case, the seriousness of the offense, the risk of recidivism, Mr. Simon's extensive juvenile record, I think was the trial court's quote, transcripts pages 7 to 9, multiple offenses already as an adult for a relatively young offender, maybe 18, 19 years old. Violation of home arrest, failure to call the bond reporting officer 3 separate times, high-risk offender under the ORAS assessment tools. The trial court took all of this into account, and so when it says in response to particular arguments that that's not his problem, he's saying, I understand the point you're making, however, I don't think that overcomes these other issues, or I don't think that that has any weight in the overall assessment.
If I may, I thought that his statement that that's not my problem had to do with the fact that he was going to have to register as an offender for a period of time, and there was really nothing he could do about that anyway.
Right.
So it's not his problem because he can't do anything about registering as an offender. He's required to under the statute.
Indeed. But I think to the extent that that argument is made multiple times, I think the appellant's argument does, I will say that the appellant's argument has more import in that sense. I'm not saying that it is certainly not reversible. I'm not saying that by any means. But if it was just the one instance in that particular context, I would absolutely agree with you. In this other, because it's mentioned multiple times, and I think the record, there's at least a way to view the record as being less than clear on that point, it's important for the trial court to have the authority and the discretion to impose a sentence based on its overall totality view of the evidence. And the fact that he's not specifically saying in that statement, that's not my problem, that you have to register, does make it slightly less than perfectly clear. But I think in that particular instance, Your Honor, you're identifying, yes, he has a duty to register as a sex offender because of his convictions for unlawful sexual conduct with a minor and illegal use of a minor and nudity-oriented material. Absolutely, he has an automatic obligation to register. There's really no discretion. The trial court has no ability to do anything else.
Well, his argument obviously is that the registration in and of itself is obviously supposedly for the protection of the community.
Indeed.
And the recidivism. But, and this is probably something I should have asked him, maybe I'll ask him on rebuttal, but I guess I'm just not sure. It's not like that requirement to register a specific factor that you have to look at.
True.
You know, it's not like the legislature's like, and you shall consider the fact that he has to register. So I'm just not sure what that really means.
I don't think it has much weight in this particular case. If the court determines the context of the court's multiple responses, that's not my problem, are related back to the sexual registration, the sex offender registration requirements, then clearly the court really had no choice. It doesn't have any weight. If anything, if the court determines that that's not my problem line was somehow improper in some sense, which I'm not conceding it was. But if the court makes that determination, at the end of the day, that's still harmless because the court had no requirement to consider it and it ultimately didn't affect whatever sentence the court was going to impose.
Yes, what I was getting at was the fact that if the court even just said, I'm not going to consider that, because that, to me, is irrelevant, because everybody that commits a sexual offense
Has
to
that duty
register.
anyways.
So I'm trying to figure out, even if we take that at face value, and he says, I'm not going to consider that, what does that relate to?
Well, the court's not required to consider it under 29, 29, 11, or 12, or 13, or any of the 29, 29, 18 overall sentencing factors. For felony sentences, none of that's required by the court, and so to the extent that the court failed to do something it had no duty to do, that cannot be error. And even if it was error, then it clearly wouldn't be any prejudicial error, it would be harmless. If I could move on, there's at least some discussion, I know we've had this argument in other cases before, there's at least some discussion about the standard of review for felony sentencing, and I won't belabor that point too much, but I will note that on brief at least, Mr. Simon argues that there is no abuse of discretion review in the state, right? That he argues that 295308G eliminates abuse of discretion review and requires findings to be supported by the record. Now, we've had this argument several times, but I will note that in his brief, he cites several other districts that have held that the General Assembly in House Bill 86 in 2011 specifically repudiated the abuse of discretion standard in favor of the standard it lays out in the statute. To the extent that he makes that argument, I agree. I think we differ on how to interpret 295308G2. The state believes that that standard requires findings, as the General Assembly specifically provides in the statute. And in the absence of required findings, because the General Assembly has not revived any findings for non-consecutive sentences, the court's review is rather limited. Obviously, I think Mr. Cannon or Mr. Simon would take a different view, but I leave that for him to address maybe on the level. But in this case, the juvenile he had an extensive juvenile record. Multiple offenses as an adult, including 3 counts of disorderly conduct in 2013, an assault charge in 2013, a domestic violence charge in 2013, and a separate theft offense while he was on bond in this particular case. He did poorly in the juvenile system. There were at least 2 separate victims in this case who were identified, and a pattern of activity in how he operated that the trial court clearly recognized and determined the appropriate sentence in response, even if this court were to conduct abuse of discretion review. You still cannot substitute your judgment for that of the trial court. As long as the court considered the factors he was supposed to consider and made a sentence that was not contrary to law, the sentence must stand. And for all those reasons, unless the court has any further questions, I would respectfully ask the court to affirm. Thank you very much.
Thank you for your time. You still have less than 5 minutes.
Thank you, Your Honor. At the outset, I would agree that the cases cited on brief in regards to the felony sentencing versus the Kalish test in 295308G. The cases cited were State v. Cobb. It did not address House Bill 86, and that was a 2014 case. State v. Carr did not address House Bill 86 as well, and State v. Brooks all were decided by this court after the amendment to the statute was made, addressed House Bill 86, but it was in a consecutive sentence case. So this, as indicated, this is not a consecutive sentence case, and I would agree that we have the burden of proof as far as the presumption to overcome that this was the sentence was allowable under the law, and that's what causes me so much trouble is the trial court indicating over and over again, not my problem. And that's what I was, obviously you heard my line of questioning with your opposing counsel. So even if the court meant what it sounds like it meant and what you're alleging, what does that really mean? Trebor is entitled to be sentenced and have the factors considered. And
but how is that a factor?
If the court explicitly says that if the court explicitly states, I'm not taking this factor into a consideration, even though the statute requires to that
The statute requires what? It requires to look at the protection of the community, recidivism, those type of things.
Correct.
It doesn't specifically say you have to take into consideration the fact that he has to register as a sexual offender.
Correct, and I would indicate that you could buttress that under one of the other different factors that the statute does list, as they are numerous, as one of those, offender is not favorably or to favorably respond to the sanctions previously imposed in adult or juvenile court. That applies to his juvenile record, but there are other factors that I think that the sex offense registration requirements may be able to be taken into account. And it was the reoccurrence of those comments, because it just gives the impression, and why we're here, to how did the trial court fashion the sentence. And so, and this court has said over and over again that a sentence is void and a criminal defendant can be resentenced. So in that case, that's what we were asking, is for Trebor's sentence to be vacated and for him to be remanded back to the trial court for a sentencing hearing, based upon all the arguments we've made. And unless the panel has any other questions.
I don't think so.
Thank you so much.
Thank you. Thank you both for your presentation to the court. The court will take the matter under advisement and will send you a written opinion as well as post on the website.
Thank you.
Thank you, Your Honor.